I asked you questions to form the base for this conversation because you handled most part of this particular trial. I'm just going to bring you and then I'll come to Richard Ayan. But you've heard...
That is why I'm saying all of them are conjecturing.
This?
Yes.
Conjecture?
Yes.
Hamza, let me have
First of all, good morning to you. Good morning to our seniors in the studio and our cherished viewers out there. You see, I have listened to Senior and the Apia Kobi, and I'm left with one irresistible conclusion on this matter. And that is the unfortunate level of dishonesty characterizing... No, I'm coming, please.
Hold on.
Please. The unfortunate level of dishonesty that characterizes our political discourse, and most importantly, especially when it comes to judgments of our high courts. And I say so because, first, a claim has been made by a judgment that Senior Andy is brandishing everywhere.
Brandishing everywhere.
But you just did.
But you say everywhere.
Please.
It is on this.
Hold on.
Not everywhere. Let me correct you, please.
Okay.
Brandishing everywhere. What does that mean?
All right.
It means I'm doing it not on one forum. Everywhere means everywhere.
Claiming that this.
But I've just done it here. So say it on this platform.
No. Hamza, let me hear you.
Claiming that this is a document that emanates from the High Court judge, and that it was not signed, it was prepared ahead of time, and to the extent that this is a document that is not signed, it presupposes that...
I did not say it is not signed. Please quote me well. I did not say it is not signed. I said that, you see, there is a...
There's no court
Yeah, he
stamp.
said it's not been certified.
I said it's not certified. That is not signed.
That's the
certification is different from signing. Please, let's get our words. We are talking law.
You said it was not stamped, not so.
I say it was not certified, yes.
They are close.
But I didn't say it was not signed.
They are very close.
They are not certified. They are not the same.
Thank you.
So, first of all, this is the first time I'm hearing this, and this is your claim. We all know how we get judgments from the courts.
Yes.
I don't know how you got your judgment, but I'm pretty much convinced, the information I have, that those claims are unmeritorious.
Those which claims?
Oh, that the judgment was... Wontumi probably had access to the judgment before he was sent in there.
But am I not showing you this?
And you have... Oh, but the judgment is now out. So what are you showing?
Yes, so go and find the judgment and compare.
But you made an assertion that the judgment was out even before the DD
and that
of the
is why
judgment.
I'm showing you this.
Oh, so you got it before the judgment was out? From who? No, this is a serious claim. He has just accepted that he got the judgment before the judgment was out.
I am saying that.
And are you saying you got this judgment before?
That's what he said. He has just said.
He said his mother gave
No.
Let him be liable for that.
I'm making my point. Yes.
I'm saying that even my mother in my village knew about it.
Okay.
No, but he has just accepted now that he had this before the judgment came out. On this my playback.
No, wait.
No, it's okay.
Did you get this judgment before it was delivered?
I got the content from Chairman Wontumi before it was delivered. But immediately after the delivery, I got this also I pulled it from the internet. You understand? But before it was...
Now, can I make this? I think that our viewers are better judges.
But I'm saying that unless you discredit this...
I see.
Please let me make myself.
You got the content
the
of
greatest
this
of
Yes,
from
I'm
Chairman
telling you that Chairman Wontumi himself called me 3 times before he entered the court.
And gave you the judgment.
Listen, you cannot put words into my mouth.
So, but allow me to make myself.
And he told me that he has heard that he will be convicted for 20 years. He told me.
So that's the content is referring
Yes, that is the content I'm referring to.
No, he said the content.
I got it before the certification.
Before the certification, I think. No, Mr. Jackson, thank you.
I am saying
it was the actual
judgment. The sum total of the judgment is that he will be sentenced.
Let me hear you.
That's the content he's talking
about.
And
again,
okay.
Can I make this? We can allow you to run. That is why. Another interesting claim was made to the effect that indeed even the charge sheet was defective.
That's what I'm reading.
Yes, and I'm not disagreeing with your opinion on that matter. But I'm also just asserting that any lawyer worth his salt, if you have suspicions that a charge sheet is defective, there's a process that you have to kickstart to challenge the validity or otherwise of that charge sheet. Was it done?
Go and read the address. Go and read the address. You will see
You are
it.
restrained. Please. Thank you.
When you say a lawyer was talking, what case have you done in your life before?
When you were talking, nobody interrupted
again, you should control his language.
Well, you were the lawyer who was supposed to challenge it. I didn't know.
Where's his salt? And you have not seen the challenge even on the charge sheet, and you are talking like that.
Challenge on the charge sheet. You challenge it on the charge sheet.
I think challenge it in the courtroom. The motions that he filed, you
Let me just give you a classical example. In relation to Hannah, that is not true. Both in the UK and here. And let me make my point.
Let me say, lawyer,
Make your point.
Are you going to allow us to have a decent show?
Make your point.
Make sure that you also be decorous. A lawyer was his salt, indeed.
Oh, you should have been decorous in assessing the judgment of the judge. You sat on TV, a senior counsel, and sought to impugn the integrity of a judge by alleging that she released her judgment. And you think that is an example for me, a junior counsel, to learn from you? What are you talking about? Please. And you see, first of all, I have demonstrated that the reasonable thing to do is to challenge the validity of the charge sheet. If you thought that there was something wrong with it, we saw it not long ago, 2 or 3 days ago. The Council of Hanan Aluduba, when they had concerns about the charge sheet, they did the needful by going on motion on notice to challenge same. That is what any lawyer will do.
So is it conclusive that you only do that?
You made your point.
I wanted strategy. I wanted to challenge it in the address. You haven't practiced. You don't understand. No, he doesn't understand. What he said the only thing to do is to challenge the charge sheet. And it was not my strategy.
You're being distracted. Let's maintain some decorum, please.
So, again, another interesting claim to the effect that, when it comes to the concerns that were being raised, the circumstantial evidence adopted by the judge, it is interesting that he actually even didn't seek to challenge the essence of using some circumstantial evidence when it comes to criminal trials. Because he cannot. One, if you have a witness before you, and the witness has made assertions to the effect that per his arrangement, and mind you, even before that, you presented a prosecution witness to the judge, an expert witness, an accused witness, and indicated to the judge, senior, that look, this is the person who is vested when it comes to reclamation. And questions were asked on cross-examination about the financial implications of reclamation. And your own witness accepted on oath that indeed it is not, we are not talking about small monies when it comes to reclamation, though he fell short of mentioning an amount. And a direct question was asked to you, your witness, as to whether indeed there were any financial commitments in that regard, whether Wontumi had paid for it. Wontumi had not paid. And so all the questions that were asked, understand, were questions that made it easier for the judge to connect the dots and cross the T's, and came to the irresistible conclusion that, look, Wontumi engaged with Henry Okume & Co. with the sole motive of actually engaging in illegal mining, intending to benefit from the process of that illegal mining, but not reclamation. It is one thing for Wontumi to claim that I sent him there for reclamation. It is another for Henry Okume to also claim that I was sent in there to reclaim and to mine. But at the end of the day, it is not Senior Andy Apia Kubi or Atachia who is vested in law to compare the two scenarios and reach a conclusion. It is the judge. And the judge will reach a conclusion based on examinations in chief and cross-examination and evidence available. So if at the end of the day, the judge listens to both sides and came to the conclusion that indeed Wontumi had questions to answer and proceeded at the back of that to reach a conclusion, I don't think that we can sit on this platform and say that, look, the conclusion was not sound without challenging it in the form of an appeal. My senior also made references to piercing the corporate veil and said that, it is only applicable in civil matters. That is not true. Because even if a company commits a crime against the state and the state takes steps to ensure accountability, the law permits lifting of the corporate veil to go against directors of that company. So it is not accurate to claim in law that the issue of lifting of the corporate veil is only applicable when it comes to civil matters. That is not law.
Absolutely.
That point needs to be made. And we see there is also an interesting logic, especially when it comes to this case, and it has been demonstrated. You can see the tension between senior Apia and the Kubi and that of the MPP, because they believe that he didn't do a great job. And you could see even the arguments between him and that of my brother Richard on this platform. But the reality of the matter, we can all pretend as much as we want. Evidence was presented. They were weighed. A decision was made. If you have any problem or whatsoever in relation to the decision, the appeal processes are not shut on you. And I've heard them make reference to the fact that, oh, even they were challenged, they were seeking for an interpretation and the judge proceeded to rule.
Yeah.
Richard, that is another problematic assertion and misunderstanding of the law. It is true that prior to ex parte Zanito and Co., the position of the law was to the effect that lower court judges, no, I should say from the high court, they were allowed to more or less apply the law in the way they understood it. Especially if people were alleging issues of interpretation that was in actual sense not interpretation. But even prior to ex parte Zanito, I remember the case of, there was a case...
from
Mekankan from the 70s. It was more or less influenced later on by even the Richard Anani case. The interpretation of the complaint in the provision of the act. Complaint. It was indicated in that decision that, look, judges must be more than willing to refer to the Supreme Court. But that does not also mean that when they look at the law and it is clear on the face of the record and that they can apply, they are precluded from applying. Right. They can proceed to apply. So if the judge has applied, the judges, it is your word against the judge's word. True. The judges feel that this is not an interpretation matter. Even ex parte Zanito did not say that the judge has no right to apply the law. Indeed, if you read the law, that judgment, it was clear that judges are allowed to apply. And so if you have issues, you can even raise the matter of interpretation for the first time on appeal. I'm a senior. Republic versus Dexter.
No problem.
You have the legal case gives you the authority to raise the issue of interpretation for the first time on appeal. But the point I need to make is that, look, the MPP should not use their internal confusion as far as this Wontumi matter is concerned and transpose that onto our judicial architecture to give an impression that there's something wrong with the judgment. What is wrong as far as this issue is concerned is their internal confusion. And so it must be separated. But if you read the judgment and you follow the case, the conclusion was irresistible. And those who are claiming that they have identified in excess of about 20 grounds of appeal, let them say it on this table. People are making references. People are making references to charge sheet and how defective it was.
Thank you. Hamza, thank you. Darrell, you have spent some time, this Samurai boy we're talking about, many people don't even know where it is, what is happening there. The evidence of the situation on the ground, the circumstantial evidence that the trial judge relied on. What is the reality check in Samurai boy? What's happening?
Well, Alfred, I think good morning again to everyone, distinguished guests here, panelists as well. But you see, I think for me, this discussion on the judgment, where we are now, I'm looking at the bigger picture for all of us. And yes, I mean, if you ask me about what is the evidence on the ground, you see, if you look at this case and the fact of the case, he was not convicted based on the impact of all the illegal activities on the ground. That must be said. He was more convicted on the fact that he allowed somebody to work illegally on his concession and all the other facts thereof. That's the matter. But I think somehow, boy, if you go to that particular landscape and you look at what is happening there, significant devastation beyond anything that you can think about. Just this June, when the rains came, because of all the mining, and I would say that that whole enclave, because of the impunity that people wield and demonstrate in that area, Mining has devastated the land to the extent that the Tano River, which really runs through that area, has been mined beyond point of having a channel. So when it rains, the river is blocked, diverted, and is seriously seated. In June, we saw how the floods came, and according to NADMO, over 1,500 people were displaced. So that tells you how really bad the impact of that illegal mining activity has affected that whole area. Now, I think the point has been made that, look, do we even know the size of the particular area that this activity or this conviction applies? I think that's a separate matter. But I think that for us, it's also the matter of the impunity with persons who believe that they can mine or allow people to mine on their concessions illegally without any consequences. And that is why we, on our part, without even, yes, we are mindful of the details of the facts and the judgment and all of that, but we are still very much concerned about the extent to which the import of this case is applied broadly. Because I'm telling you, Alfred, it is not only the case of the Wontumi Case mining that we have instances of people giving out their concessions for others to mine. The reason why we have a lot of the illegal mining activities are people who even have small-scale mining licenses allow others to go and mine, and then they share the proceeds or go for a certain percentage of the proceeds at the end of the day. We know of some companies on the ground who every day they have men in pickups who go to sites that they allow people to mine. So for me, I think I'm really happy about this judgment in the fact that it kind of shows you somewhat the lapses in we not applying the law as we should. Act 995 was very, very strategic. I agree. Act 703, in terms of somebody who has undertaken illegal activity and all of that, was not sufficient in terms of being punitive enough to get people who are engaging in illegal mining convicted. So even if they were convicted, 3 years max. But then the previous president said that, look, that is not enough. We want to deal with galamsey, so we need to make it more punitive. Act 995 came in and said that if you facilitate, if you aid, if you finance, even if you fabricate equipment, you are now liable to summary conviction of nothing less than 15 and nothing more than 25. So for me, even if you are conflicted about whether the, the case or the evidence, what about the bit on allowing somebody to engage? Now, I'm interested in how the government going forward will use this to go after all those people on the ground. I think that between when the case started and now, we should have had more than one Wontumi going out there, being prosecuted, not just Wontumi.
The Samurai Boy video is what we're seeing on the screen now. So would you agree with that narrative that he's a political prisoner?
I don't agree to that assertion, because from where we sit, I don't see any evidence to point to the fact that Wontumi is being prosecuted because of who he is as a politician or because of how loud he is. I think that the evidence on the ground, if you look at the judgment, is more about the fact that his company, for which he is a director, engaged or allowed, and he himself engaged in a relationship with somebody who did some activity on his land, which in law is constituted as illegal. And so he's just facing the tune of that particular bid that he himself has set in motion. So there is no way, I don't see it. What will make it look like a persecution, Alfred, is when beyond this, going forward, the case just comes to a rest and that's the end of it. Right. Because there's a lot more happening out there in the field that we think that the police, the government, the judicial, what are they waiting for? So time will tell all of us whether indeed, if this was a political persecution or indeed it was a prosecution to ensure that the environment is protected.
No, Lamata Bebo, is there any defect in this particular ruling? And what hearing from Andy Apiakobi, what is said
and
in there?
Before Senior Martin comes in, just a quick one, with your permission. I think that this is solid grounds. This is solid grounds, because I'm getting messages to that effect, that the judge in the case needs to file a petition to the General Legal Counsel for Senior Apiakobi to come and substantiate the allegations to the effect that the judgment was out and Wontumi had access to it before the judgment was made public. It is important.
I will be very happy if I'm given that
Yes.
opportunity to prove it.
And rightly so,
I'll be
we
very
effectively will disassociate
I'll be
ourselves
very
from
happy.
that
Let's file
particular
the
claim
petition.
here
And I'll be
at
very
TV3.
happy to come and
Yes.
negotiate.
Alfred, you
Thank
don't
you.
have time.
Yes.
So,
Okay. Yeah, so, let's do this. So there's naturally bias on my part. So if you say there's a defective, any defect,
This
Maybe an
description
invitation
of
for you to
Wontumi
assess-
as a political prisoner. And so let's.
No, so the first part, I think, is there any defect in the judgment? I'm saying that because of my bias, because of my bias, you won't expect that I'll do an excellent job at it. The bias being that we need to protect the forest, etc. So my reading of the judgment on the face of it, it's okay. It's okay. It's sufficient to put Wontumi where he is. It's sufficient. It's sufficient to put Wontumi where he is. Because, you see, the thing is that the judge makes the reference. Keaton, Wontumi does not deny that he gave permission to Henry Okum, right? But that permission he gave, wrong permission, because even the person who was giving the permission to Henry Okum does not have a mining support services license. You see, before you do mining support services, you have to be licensed. So he was engaged in an illegality by giving that to Henry Okum. Okum told the court that he is a small-scale miner. He's not into reclamation. Reclamation is a science, so it's not just you just cover the pits and start planting
But
trees.
the reclamation has to even be approved by the ministry.
That's what I'm saying. Yes, so it's a whole procedure and the LI. If you want to do reclamation.
application to the ministry.
So it would be, won't be the owner. Or you mean for the license?
Yes.
The license should be Henry Okum. And if you are going to engage somebody, you should be checking whether he's licensed for that purpose. It's just that you're going to hire a lawyer. You've not checked whether he's licensed. Anybody you see in the court premises, and in a suit, lawyer, can you help me? No, you first check. Are you a lawyer?
So that
Are you a lawyer?
To will not say that I am not qualified.
He says his story is that Wontumi gave him for them to mine.
The person who wrongly engaged the wrongful person is rather guilty of providing the service than the one who did not have the qualification.
Yes, because of plea bargaining. So when they approached Henry Okum, he decided to cooperate. You think if Wontumi had cooperated, it would have been this high?
Then there would be no case.
There would have been a case that, okay, go and plead guilty and then they'll give you a lower sentence. That would have been smarter for him.
But there would have been no case if what Henry Okum did, Wontumi did that. But you know, Henry Okum was selected for the convenience of prosecution. So it's not the same thing.
Did Wontumi make an offer?
It was a convenience selection.
This is for
I'm
the
going to go for
police.
this quick break. When we are back, no, you haven't finished your point. You also ask a question. We'll be back shortly. That much people, you are making your point and conclude on that now.
Yeah, so I said that, look, even on the matter of the reclamation, the person Wontumi engaged had no license. And so that in itself is a contravention. That's the one Apia Kubi was trying to say. But how about Okum himself? And we're saying that, you see, under our law, that's why we have the amendments that now allow, in broader terms, plea bargaining. So it was within Wontumi's right, to approach the AG to do plea bargaining like he's doing in a different case. So when he was confronted with all these things, if he had approached the AG to say he also wants to cooperate, he will spill the beans, etc., it would have been a different thing.
Deputy AG said he wasn't interested in it. Shams, I said he wasn't interested. That Wontumi was not interested in this.
So that is where he caused his own problem. If he had made an offer like the Exim Bank, when Wontumi made the offer in the Exim Bank case, I was one of the persons to support, and I still support. People insulted, say you are still negotiating, and we support it. We support that we should get the money back.
Thank you.
What the Exim Bank case? You are no longer doing the.
Go ahead.
Oh no, give information. The Exim Bank, you are no longer negotiating.
I'm saying the position you stated is wrongful.
Which that you made an offer.
Okay, go back to your case and talk. But I'm just giving you.
No, let's see. So that if we are giving wrongful information, nobody wants to mislead them. We are told that you approach the AG to do plea bargaining.
That is correct.
And so
but the conclusion that you just expressed is wrongful.
That is ongoing. So there's no plea bargaining on the table.
Let's go ahead.
We support it because I want to get the money back.
Now it says there's no.
Okay, so let's go. So the point I'm making is that in this case in which he's been convicted, If he had made an offer to do plea bargaining, the outcome would have been different. But he stuck to his grounds and then fought it in court and lost. So that one, you can't say that it is selective, because Ahiaba said that this is selective. Why do they take Okum and didn't take Wontumi? Wontumi didn't make an offer, because let's be fair to the facts. Wontumi didn't make an offer in this case. He didn't. Otherwise, it would have been made public. His lawyer is sitting here, the lawyer at the time. If he had made an offer to do plea bargaining, would have known. So don't say it is selective. Plea bargaining is voluntary.
It's voluntary. This one is not even plea bargaining. So, lawyer.
Oh, I'm done. Let's go. Let's just two statements. Let me tell you. Look, reading the case, there's one side that we need to, between Okum and Wontumi, reading the judgment, you can see a lot has been left unsaid. So it means that they buried a lot more of the evidence. Yes, between Okum and reading the judgment, you see that he
let me hear from
did Wontumi a favor.
Alfred, today is one of those days that you need to get extra time, because literally...
make your point.
No, but I need to... I can't make any point with what time you have. You understand? The point I'm saying is that you should have more time. At least you should advocate for that. You know what I mean? Literally like 57, 58, 2 minutes.
So you're
like,
not
what
going
am I going to say? We said Wontumi is a major case. He's a political prisoner.
Okay.
Between all the things, between Hamza, my brother, and lawyer Kwebu, everything they said just shows that Wontumi should not be in prison.
Really?
Yes, because this circumstantial evidence on basis of which Wontumi is in jail, okay, actually should have been in his favor. The doubt created in this case should be in Wontumi's favor. But somehow, he is rather suffering it.
But who says a doubt was created?
But the whole thing, the case is doubtful here. There is no concrete evidence that... but we have read the thing. No, we have read the thing.
The judge on
But we have read the judgment. This is the judge. Is that not it? His judgment is the judge, isn't it?
Yes.
That's the statement. I'm saying that reading this
to the conclusion. Are you an expert? Are you a judge?
Well, it is. But we have just read the English he has brought, which then says that, oh, no. Oh, come on. Hamza, hold on. But so you think that it is concrete. We think it's not. Then you think what you believe is
expertise.
But what do you mean? What do you mean expertise? Don't we have common sense? This thing that people do. Oh, no. Please.
I think we need to
this. Yes, there's a common sense. The law is it rocket science? No,
it's seriously flawed.
Please.
Anybody to go and represent you.
I see this is not correct. No, you are only your credit. See, Hamza doesn't want me to talk. Jesus Christ.
To go and appeal this. It says you are going to appeal. That's what.
Yeah, but the point I am making is that you have gone to court once. The man who actually did the small scale money, is he?
Unfortunately.
Alfred, I am very...
Thank you.